Part one of this discussion covered the matter of the very notion of what it is to be a traditional Catholic, what it is to be traditional and therefore Catholic. And it also talked about some of the dangers that beset traditional Catholics today that would make them not traditional and therefore not Catholic. And I said at the conclusion of part one that I would cover some of those very practical decisions that traditional Catholics have to make, which threaten their very honesty in calling themselves traditional and Catholic. Now, having rightfully and rightly rejected the corruption of the New Order religion, faithful Catholics, clergy, and laity confront a number of grave problems for which they do not have the solutions. The temptation will present itself to simply cast aside all restraint and take initiatives, to presume prerogatives and competence which they do not have in order to solve these problems. They'll be looking to find solutions for which there is no precedent in Catholic history and which Catholic tradition nowhere endows them. Here is a real and present danger for traditional Catholics. By exceeding their competence in addressing the problems facing the Church, they would become no better than the New Order religion. Satan, who has inflicted this crisis on the Church, will certainly strive to mislead those who have escaped the modernist trap to fall into another equally disastrous trap of a false reaction. And the only safeguard we have against backing into the trap of inventing human solutions to supernatural problems is to adhere firmly to Catholic tradition as known by law, Catholic practice, and historical precedent. To illustrate this point, let me offer several examples of the temptation to exceed the competence afforded by Catholic tradition. The first example I would offer as a temptation to exceed our competence is that of marriage annulments. Those Catholics who have been associated with the priests of the Society of St. Pius V for any length of time know that we will not presume to grant marriage annulments. In cases where a marriage is automatically invalid according to law, as when, for example, a Roman Catholic attempts to be married by a Protestant minister or a justice of the peace, then we do simply acknowledge that the law itself declares such marriages to be null and void, in which case the parties involved were never validly married in the first place. However, in those cases which required a solemn judgment of the Catholic Church, as for example in cases questioning the proper intention necessary to marry validly, then we simply admit that we do not have the competence to judge such matters. The annulment of a marriage is a complex process with far-reaching and profound consequences. It is not just the statement of an opinion. It is a declaration of authority, and no simple priest has the authority to grant an annulment of marriage. Some years ago, a priest visiting me suggested that the traditional Catholic clergy in America get together to elect 3 priests to constitute a marriage tribunal. When I protested that we lacked the competence to rule on such cases, he said it would be a simple matter to choose 3 priests who would review the facts in marriage cases and grant or deny annulment requests. I asked him what would happen if all 3 failed to agree. Decisions, he said, would be by majority rule. 2 against 1, he said, and what of those priests, I said, who would disagree with the decision? He explained that all priests would just accept their decisions in advance. Now, this is a clear-cut proposal for priests to grossly exceed their competency in dealing with the matters of the utmost delicacy and sacredness, which traditionally required years of highly skilled investigation, and finally an authoritative decree of judgment by the Holy See. How a traditional priest could seriously suggest that a number of priests get together and form their own marriage tribunal is beyond me. This, to me, manifests a complete lack of understanding of the authority necessary to deal with marriage cases. And it expresses also a complete lack of understanding of the restraints and constraints placed upon traditional priests by Catholic tradition itself. There is no precedent for Catholic priests daring to rule in this way as this priest suggested. Now, another such case is that of those who claim to be sedevacantists, but actually take that step beyond the confines of sacred tradition. And I'm talking about the sedevacantists who say, in our opinion, John Paul II is not the Pope. Therefore, everyone must accept as a dogmatic fact that he is not the Pope. And if one is not willing to say with absolute certitude and conviction that John Paul is not the Pope, that person cannot be a Catholic. Now, this is a clear and manifest case of exceeding the competency afforded to us by Catholic precedent, by the precedent of Catholic history and law. We know that one of the most pressing and perplexing problems facing traditional Catholics is their relationship with John Paul II, whatever that might be. They are Catholics, and Catholics by nature revere and obey the Pope. But can they obey John Paul? Is he the Pope? Does he have the faith? Does he profess the Catholic faith? Now, there are basically three schools of thought possible on this subject. The first is, John Paul is certainly the Pope, but he need not be obeyed when we disapprove of what he says. The second position is, John Paul II is certainly not the Pope, and only those who are perfectly convinced of this can be Catholics. The third position is this: there is at least an objective doubt regarding the papacy of John Paul II. Now, position one is the most preposterous and un-Catholic of all possible positions. To say that John Paul II is certainly the Pope, but we don't have to obey him when we disapprove of what he says, is manifestly a schismatic statement. Position two, on the other hand, holds that to be a true Catholic, a traditional Catholic, a Roman Catholic at all, one must be absolutely convinced that John Paul II is not a Catholic Pope. Now, there are those who have come to make this statement today, even going so far as to say that it is a dogmatic fact that John Paul is not a Catholic Pope, and therefore, to be a Catholic, one must reject him absolutely. There cannot be a shadow of a doubt in the person's mind that he is not the Pope. Now, is this true? They appeal to this notion of dogmatic fact to ground their opinion and then to elevate it to the level of a dogma or a doctrine, making it an absolute requirement to be Catholic that one be convinced with no hesitation that John Paul is not the Pope. So we have to go into this question of a dogmatic fact just for a moment. Now, dogmatic theologians do deal with this question of a dogmatic fact, and they define it. A very, very well-known dogmatic theologian, a French dogmatic theologian named Hervé, has this to say. He says, a dogmatic fact is general. In general, any fact so connected with dogma that it is necessary for the acknowledgement, the guarding, the applying, or the rightly proposing of that dogma. He says this fact can be distinguished in a threefold manner. And he says principally a dogmatic fact is an historical fact by which a rule of faith is known. For example, the legitimacy of an ecumenical council or the legitimacy of a pope. So you see, the question of a man's papacy really does fall within the province of a dogmatic fact. Another great dogmatic theologian, Valentinus Zubizarreta, a Carmelite priest, had this to say: dogmatic facts are not in exact terms, but only equivalently revealed by God. And they speak such a relation with some revealed dogma that for the sake of that doctrine's conservation, they must be kept as though a patch were kept on the roof. Of this kind are that the Ecumenical Council of Trent is a rule of faith, that Pope Pius XII is truly a Roman pontiff of the Church, that Saint Teresa, solemnly canonized by the Church, is in fact in heaven, that the Vulgate edition of the Bible is authentic sacred scripture. Note that this theologian, Father Zubizarreta, holds that dogmatic facts are formally implicitly revealed by God because they are so closely revealed with a dogma of the faith and with the Church's infallibility. There are truths so necessarily connected with divine revelation that they cannot be denied or called into doubt without that revelation suffering injury from that denial. Now, the question arises, can the non-papacy of John Paul be a dogmatic fact? Now, in the first place, let's say this. We have to remember that the Church tells us that if a man has been duly elected and is accepted by the moral universality of the Church throughout the world as the Pope, then he is the Pope. It is a dogmatic fact that that man is the Pope. But is it true to say that a man not being the Pope can also be a dogmatic fact? I believe it is doubtful, and I say this for this reason. Because the fact that a man has been duly elected and is recognized by the universality of the Church throughout the world are patent facts. They can be proven or disproven, perhaps. But to reach the conclusion that for other reasons a man is not the Pope and cannot be the Pope requires a long series of proofs and deductions, premises that are based upon evidence, and a lot of evidence. And so by the time you come to the conclusion, therefore, this man cannot be the Pope, you have such a string of reasoning bringing you to that conclusion, it is very doubtful that that can be so intimately connected with divine revelation that it is a dogmatic fact, unless, of course, the man simply come out and formally deny a truth of divine revelation. This is my own personal reflection on the matter. It is not the negative equivalent of the classic examples of the theologians. This is what they say, or would say, about John Paul. A man who is duly elected and acknowledged to be the Pope by the Universal Church is the Supreme Pontiff and Vicar of Christ, but John Paul has been duly elected and is acknowledged to be the Pope by the Universal Church. Therefore, John Paul II is the Supreme Pontiff and Vicar of Christ. This is how the Novus Ordo theologians would argue this matter of dogmatic fact in talking about John Paul. Now, the first proposition is of faith, that a man duly elected and acknowledged to be the Pope by the Universal Church is the Supreme Pontiff and Vicar of Christ. That is of faith. The second is considered to be an objective fact which one can verify, whether this man has been duly elected and is acknowledged to be the Pope by the Universal Church. To prove the conclusion wrong, one would have to demonstrate that John Paul was not duly elected, or that he is not acknowledged to be the Pope by the Universal Church. But assuming one could do this, again, would that necessarily make it a dogmatic fact that he was not the Pope? I do not believe so. I think it would have to be proven that it would. An alternative would be to try to prove that he had perhaps been elected, perhaps been acknowledged at one time, but that he had lost the papacy because of heresy, that he had defected from the faith. But even here, some serious Catholic theologians say that a pope who lost the faith would have to be deposed by the church before he would cease to be the pope, that he would not automatically cease being the pope. I'll get back to this question in a few moments. This is authority question. I believe it is stretching things to claim John Paul's non-papacy as a dogmatic fact, and that no one can be a traditional Catholic unless he's absolutely convinced of it. After all, we must always remember this. Even if it were a dogmatic fact that John Paul were not the Pope, the opposite would still only be a sententia falsa, that is, a false opinion or a false proposition. It would not be a heresy, and one would not cease being a Catholic for holding it. Thus the contention that no one can be a traditional Catholic unless and until he believes and has absolute certitude, without doubt, that John Paul II is not a true pope, is another case of a priest exceeding his competency. Such a judgment presumes to bind the consciences of all the faithful. That authority is proper to the magisterial authority of the Church. There is no precedent in the Church tradition of an individual priest possessing the authority to pronounce such a judgment, which is tantamount to a dogmatic decree, obliging de fina et catholica, that is, obliging by an obligation of divine and Catholic faith what is essentially his own opinion. This is an exceeding of his authority and competency. No priest has the right to do that. But he would turn around perhaps and say, but wait a minute, unless you're absolutely convinced that John Paul is not the Pope, then you must obey him. This is what most of the sedevacantists who adopt this extreme position say. They say, you cannot be a traditional Catholic priest unless you can say with certitude, absolute conviction, that he is not the Pope. Well, I say to them that they're wrong in that. And I can back that up. One does not have to have absolute certitude that a man is not the Pope in order to disregard what he says and continue functioning as a traditional Roman Catholic priest. And the first authority that I would adduce to establish that fact is that of an apologist for the faith in 19th century England, a very well-known writer by the name of Father Ryder of the Oratorian Fathers, in his work on Catholic Controversy, published in 1882. This is what he said about the papacy. He said, I answer, first, that it has always been maintained by Catholic theologians that for heresy the Church may judge the Pope, because, as most maintain, by heresy he ceases to be the Pope. There is no variance on this head amongst theologians that I know of, except that some, with Terracramata and Bellarmine, hold that by heresy he ipso facto ceases to be Pope, whilst others with Cajetan and John of St. Thomas maintain that he would not formally cease to be Pope until he was formally deposed. The privilege of infallible teaching only belongs to an undoubted Pope, and on the claims of a doubtful, disputed Pope, the Church has the right of judging. And then he goes on to say this, and this is extremely important. During a contested papacy, the state of things approximates an interregnum, that is, a gap between popes, after one pope has died and before another pope is elected. During a contested papacy, the state of things approximates an interregnum. The exercise of active infallibility is suspended. It is a paralytic seizure which has been permitted now and again to afflict the Church for a brief space, in order that we may know the more how to appreciate the vigor of our normal ecclesiastical life. Well, actually, Father Ryder is simply voicing the words of Our Lady at La Salette, and especially at Fatima. Our Lady predicted that these vaporations, that our Lord would strike the church, that our Lord would afflict the church for a brief space. This would be a great chastisement. So it should not surprise us that such a thing is possible and could happen, and in fact is happening even today. But what is important is to listen to the words of Father Ryder, that even if a pope's legitimacy were contested or doubtful, his infallible powers would be suspended. He could not use them. Why would even a doubtful pope's infallibility be withheld? Even should the doubt eventually be dispelled and he be proven to have been the pope all along, nonetheless he could not exercise his papal powers. Well, I think the answer is given by the reflex principles of the Church. There are reflex principles which enable theologians and parish priests to decide moral questions in which the facts involved may not be entirely clear. Father Dominic Prummer has written in his Manual of Moral Theology of 1923, indirect or reflex principles are certain general, true, and clear norms which, while they do not directly and per se prove the thing concerning whose truth is being investigated, but nevertheless they serve to dispel the practical doubt and to obtain moral certitude in a practical case. Father Prummer then lists the more important, the principal, he says, the principal principles, the more principal reflex principles. And at the top of the list is this: lex dubia non obligat. A doubtful law does not bind. Now, certainly, if the authority behind a law is doubtful, then the law itself is doubtful. If the law itself is doubtful, because based upon doubtful authority, then the doubtful law does not bind. If there remains an objective doubt concerning whether a man is a true pope, then his authority is necessarily doubtful. And if his authority is doubtful, whatever commands he gives must also be doubtful, and therefore those commands or laws would be doubtful and they would not bind. This is simply applying this reflex principle of moral theology. Thus, if the reforms, the changes in the Church, do not constitute an objective, prudent, and reasonable doubt concerning the authority and Catholicity of those responsible for them, I mean the post-Vatican II popes and their followers, then both they and their authors must be accepted and obeyed. But if the changes in the Church must be rejected in conscience, because they are a grave attack against the integrity of the faith, then necessarily they constitute an objective doubt, and they give us an objective doubt about the authority and the Catholicity of those responsible for them. They call into question the authority of John Paul, of Paul VI, and so on. That doubt that says these destructive acts cannot possibly be the work of Christ or of His Church. Now these are very important points to make here, because it is not necessary for one to have absolute conviction that John Paul II is not a legitimate pontiff in order to function as a true Roman Catholic priest or to continue to function as a Roman Catholic layman attending the traditional Mass and practicing the traditional Catholic faith. Absolutely not. All that is necessary is to acknowledge the fact that there is an objective doubt about the papacy of John Paul. One need not say, I am absolutely convinced that he is not the Pope, although one could say that. Personally, he is convinced of that fact beyond a reasonable doubt. But in saying that, he must say it is only logical that John Paul is not the Pope. But it is only logical. It is not a doctrine of faith. It is not a dogma. He cannot impose that on the consciences of others. Sure, he may say, well, the facts lead inevitably to this conclusion. Well, perhaps they lead him inevitably to that conclusion by the process of reason and logic. But the fact that another, by the process of reason and logic, has not led to the same conclusion does not make that other person a heretic, but does not make him a non-Catholic. There has to be an authority which declares the things that are necessary to be believed by all Catholics, and that if they don't believe it, they cannot be Catholics. And that authority is not possessed by any of these individual priests. They can say, it is my opinion, it is only reasonable, it is only logical to believe this, but they must always remember, yes, it is only reasonable, it is only logical, it is not divine revelation. There are some theologians who say that if a pope were to fall into manifest heresy and formal heresy, he would automatically stop being the pope. But you see, that would have to be proven, and it would have to be proven to all. And a person to whom that had not yet been sufficiently proven would not necessarily stop being a Catholic because it had not been adequately proven to him, and he was not necessarily convinced of it. Yet there were other theologians who held that even if a pope were to fall into manifest and formal heresy, he would not formally cease being the pope until he had been declared such by the Church. That has not taken place yet. And so those priests who dare to impose this as an obligation of Catholic faith, to say that John Paul is most certainly not the Pope, are exceeding their competency. Not only that, they are exceeding their honesty, because they themselves do not practice the consequences of what they say. One of these priests, who is perhaps the most outspoken nowadays about this issue, himself acknowledged to me, in the very same breath in which he was upholding this quasi-dogma of John Paul's non-papacy, that fully 75%, in his estimation, of his own people in his parish do not firmly hold to the non-papacy of John Paul II. They admit that he might be the Pope, or they simply say they don't know, they question it. But he still does give them Holy Communion. He still does recognize them as Catholics, even though they are not ready to accept his pseudo-dogma. And therefore, I think this is outrageous that a priest should presume this authority to make it a matter of divine and Catholic faith that John Paul II is not the Pope, when there is so much confusion rife among the Catholics. By the way, I should also point out this fact, that the very priests now who are leading this charge and trying to make it of divine Catholic faith that one accept this pseudo-dogma of theirs, 10 years ago were men who were both using John Paul II's name in the canon of the Mass and urging others to do so. Now, in the course of the last 10 years, they have changed their opinions drastically and radically to the extreme opposite. And the reason they explain this is they say that now so many things have taken place to make it clearer that John Paul is not and cannot be the Pope, that everybody must recognize it. Well, I would say to them, fathers, be reasonable. Surely you cannot say that once you have figured out that he's not the Pope, everybody has to see it clearly also, as though you were the last ones to be able to figure it out. And that means it must be so evident that everybody must see it. Surely that's not what you could mean. And secondly, I would say to you that it was perfectly clear back in 1979, while you were still using John Paul's name in the canon of the Mass, it was perfectly clear to other priests that he was not the Pope or did not have the Catholic faith. They even raised this point with you, and you told them that they couldn't say such things. Or you told them it was a matter of opinion. Now you've drastically changed your opinion. That should make you realize this can't be a matter of dogma. It's a matter of gathering facts and reasoning to a conclusion. What John Paul II said to the United Nations General Assembly in 1979 was no more Catholic than what he did at Assisi or what he said at the Jewish synagogue in Rome. It was outrageous what he said there, and it cannot be reconciled with the Roman Catholic faith. You should have known that. And if that was not enough to convince you in 1979, why you can claim now in 1993 that everyone must now see it clearly because of subsequent developments. I think you're, again, exceeding your competence, and I think you have no right to enjoin this upon the traditional Catholic faithful, as you yourself acknowledge. Even the majority of your own followers, or the people you serve, do not see things as your way, do not see it as a dogma, and yet you accept them to be Roman Catholics as much as yourselves in practice. So please drop the pretense. Another case of Catholic priests, traditional priests, exceeding their competence lies in this matter of the Thuc bishops. Of all the concerns which traditional Catholics have concerning their hopes for the future, they depend upon the raising up of true traditional Catholic bishops to shepherd the Catholic faithful and to ordain for them valid and devout priests. Now, some years ago, the Miami Voice, a so-called Catholic publication, candidly stated that the whole strategy of the Vatican was to prevent Archbishop Lefebvre from consecrating any bishops, since without them his movement would necessarily eventually die out. In order to perpetuate itself, any traditional Catholic effort must have bishops. No bishops, no priests, no priests, no Mass. No Mass, no Blessed Sacrament, no absolution in confession. Without these, one can hold the faith, but one cannot fully practice it. Now, some have sought to remedy this lack of episcopal power by seeking to obtain bishops or obtain episcopal orders in a variety of ways. One priest who visited Bishop Antonio de Castro Mayer in the late 1980s came away from his visit in Brazil saying that the bishop had told him, "Go to Gerard. If it's good enough for Gerard, it's good enough for me." He was referring to Gerard de Laurier, a Dominican priest who had been consecrated just shortly before by Archbishop Ngo Dinh Thuc, a bishop from Vietnam who had left Vietnam after the assassination of his brother, who had been the president of that country, and had then wandered in ecclesiastical circles, gotten into various troubles with the Vatican, and finally had settled in France. This Father Gerard de Laurier had gone to Archbishop Thuc to be consecrated a bishop. And supposedly the statement of Bishop Antonio de Castro Mayer endorsed this consecration and even encouraged this priest to go to Father Gerard de Laurier for perhaps ordinations of priests and even consecration of bishops. But one gentleman who was present throughout the conversations between this priest and Bishop de Castro Mayer, a man who speaks both the bishop's native Portuguese as well as French, in which the conversation took place, disputes that interpretation of the bishop's words. The gentleman who had known Bishop Mayer for several years before this meeting states that the bishop did not say such things and did not mean what the priest visitor has since claimed. That Bishop de Castro Mayer was endorsing the Thuc consecration of Father Gerard de Laurier and encouraging this priest to approach him for holy orders was not the case. Now, I think it's important to look at this particular consecration for two reasons. First of all, the consecration by Archbishop Thuc of Father Gerard de Laurier is a consecration which has ramifications that are going to affect true Catholics, traditional Catholics, for years to come, because there are successions that have followed from Father Gerard de Laurier that are affecting Catholics in Italy and Catholics throughout the United States, actually throughout the Americas. There are people who are going to priests or going to bishops who follow in the line from Father Gerard de Laurier who are affected by this question. Is he really a bishop? Was he really a bishop? Can we accept the orders that have come from him in clear conscience as being valid? Very, very serious questions. Nothing to be trifled with. And the second reason why I think this particular consecration needs to be dealt with is because more is known about this. A number of our priests traveled to Germany to deal with the only living observers of the consecration. I call them observers as opposed to witnesses, and I'll explain why. First of all, let's review some of the circumstances of this consecration of Father Gerard de Laurier by Archbishop Thuc. Circumstances that were revealed under oath by the two observers, two university professors at the University of Munich, Professor Hiller and Professor Heller. Both men testified under oath to the three priests who traveled to Munich to interview them back in 1989. These three priests were Father Donald Sanborn, Father Clarence Kelly, and myself, Father William Jenkins. First of all, the two men both testified that the consecration, that the ceremony was meant to be deliberately secret. But the request of Father Gerard de Laurier himself, everyone was to be excluded from the ceremony except Archbishop Thuc and these two observers who were there only in the capacity of servers. They were not briefed on the ceremony, they were not trained, they looked over the ceremony themselves in the airplane on the way to actually serve at the ceremony. They received no instruction as to what constituted the matter and form of the order to be conferred. They could not identify what it was, and this is extremely important to qualify them or disqualify them as witnesses. This is why I call them observers. A very important point that was also brought out, and this was brought out under oath, was that there existed no official documentation of this consecration taking place. There was no certificate issued. There was no certificate originally requested by Father Gerard de Laurier. There was none offered by Archbishop Thuc. There is no documentation, as I say, officially required by the Church to substantiate that this consecration took place and took place properly. It is not recorded anywhere in any official archival document. There were no witnesses, as I say, who are living now who could testify that the matter and the form were applied properly. The witnesses were able to testify, and in this case I think they can be accepted as witnesses, concerning something over which they would testify as far as their personal knowledge. They both testified that Archbishop Thuc had the mind of a child at this time. That was what they said, the mind of a child. In fact, this is how they explained that only 3 weeks before this ceremony allegedly took place, Archbishop Thuc had concelebrated the new Mass in the local Novus Ordo church. That he had gone through the motions of concelebrating the new Mass, and when asked later how he could have done that, he said he did that as a token of friendship, because the Novus Ordo priest had shown him some kindness. But Archbishop Thuc said, and this was testified again under oath by these men, Archbishop Thuc said he withheld his sacramental intention while performing this quasi-sacramental function. Now this is a very, very indicting statement, because not only does this in itself constitute a mortal sin to do such a thing, to go through the motions of performing a sacrament to withhold an intention, but it was justified by these men by the fact that he had the mind of a child. The fact that 3 weeks before he had gone through the motions of performing a sacrament withholding his intention does cast kind of a shadow, or a bit of a shadow, over any sacramental ceremony that he would perform later. Now, another factor which has to do with the intentions of the men involved, the principles involved, Father Gerard de Laurier and Archbishop Thuc, also must be taken into consideration. And this intention is testified again by the two observers whom I mentioned. but also by a priest who was a close associate, perhaps the closest clerical associate of Father Gerard de Laurier's in these years, preceding and immediately following this alleged ceremony of consecration. This man's name was Father Bernard Lucien. And Father Bernard Lucien has written to verify the fact that Father Gerard de Laurier stated publicly and emphatically that he had no intention, and in fact, I should put it this way, that he had the positive intention not to be consecrated a bishop by any bishop who recognized John Paul II as Supreme Pontiff of the Roman Catholic Church. Why was this? Well, as it was explained, Father Gerard de Laurier believed that if any bishop who would consecrate him accepted John Paul to be the Roman Pontiff, that consecration would be schismatic. And Father Gerard de Laurier did not want anything to do with the schismatic consecration. And so Father Gerard de Laurier did inquire of Archbishop Nodin Thuc if he did reject John Paul II as pontiff, and allegedly Archbishop Thuc said yes, he did reject John Paul II's pontificate. But our two observers did again testify under oath that during the ceremony that they saw, Father Gerard de Laurier was repeatedly interrupting Archbishop Thuc during the initial part of the ceremony, because Archbishop Thuc, who had just told Father de Laurier he did not accept John Paul II's papacy, was repeatedly invoking John Paul II's name during the mandatum section of the ceremony, according to which the name of the Pope who gave the mandate for the consecration is mentioned as the authority authorizing the consecration. Father Gerard de Laurier repeatedly interrupted this part of the ceremony, the mandatum, to admonish Archbishop Thuc that he must not invoke John Paul II's name. Yet the two observers insisted that the ceremony was followed exactly. There are contradictions in the testimony. I'm sure the two men, I believe the two men were of goodwill and are very honest, but there are points in their testimony that are at variance. But this whole question of Father Gerard de Laurier's intention is very important, because if Father Gerard de Laurier made the firm intention not to be consecrated by any bishop who recognized John Paul, and then Archbishop Thuc was invoking John Paul repeatedly during the ceremony and had to be corrected by Father de Laurier, how does this affect the intention? The intention not to be consecrated, stated beforehand. We know afterwards, after this ceremony allegedly took place, that Archbishop Thuc did make statements of acceptance of John Paul II. Again, how does that affect the intention of Father Gerard de Laurier? These are questions that have to be faced. They are not trivial questions. Again, the evidence for them is all attested under oath by people who are able to testify as to these historical facts. And the only possible conclusion to all of these is that these and other facts give rise to a prudent doubt, which can be overcome only by serious and reliable evidence. Now, some priests have found what they believe to be compelling evidence that this consecration by Archbishop Thuc of Father Gerard de Laurier must be accepted as valid, despite all of the problems and despite the fact that there were no witnesses present who could certify that the consecration was done properly, that is, with the essential matter and form. One priest recently wrote a preface to a booklet vindicating the validity of Father Gerard de Laurier's Episcopal consecration and criticizing those priests of the Society of St. Pius V who contest the validity or the acceptability of that consecration. The priest who criticized our priest of the Society of St. Pius V, the priest who insists that the consecration of Father Gerard Laurier must be accepted uncritically as valid, had this to say about the matter of one bishop secretly consecrating another without assistant priests as witnesses. And I quote him here. "I discovered that Pope Benedict XIV discussed the matter at length and said that the whole question was settled by Pope Alexander VII, who said that even if a bishop without a papal dispensation should, without any assistant priests, perform an episcopal consecration, it is to be deemed valid. Furthermore, I found no mention in any writings of a pope, theologian, or canonist of the necessity of having, quote, qualified witnesses at an episcopal consecration. Eager to transmit this important find to the priests of the Society of St. Pius V, I sent to each of them in January of 1991 a packet of documents in support of the fact that even consecrations at which there were no assistant priests, even illegally, had to be deemed valid. In the packet I included a letter in which I said," and this is a quote then within the quote, a quote addressed to our priests. "To date, January 16th, 1991, I have not seen a single document of either the Church or a theologian or a canonist which states that if a consecration is performed without at least one assistant priest, it is to be deemed dubious or invalid. If anyone has such a document or information, could he kindly send it to me?" And then the priest returns to his original document. "As of this writing, January 1992, I have not received a single response, and I therefore assume that there is no such document. In the face of this, I do not understand how ordinary priests can maintain that you must regard a consecration dubious which does not have qualified witnesses, when Pope Benedict XIV attests that Pope Alexander VII declared that even consecrations without any assistant priests must be deemed valid. Nor does either of these pontiffs, nor any canonist or theologian, say that qualified witnesses are necessary in the absence of these assistant priests." Now this is quoted from a preface written by this priest, a preface written to an article published under the title, "The Validity of the Thuc Consecrations." Now, speaking for myself, it is quite true that I received the information sent by this priest in good order, and I did not respond within the time stated by the author. There are several reasons why I did not respond, which will serve partially to answer the point our critic is attempting to make. In the first place, I did not respond because I had asked the priest on two separate occasions to write a formal statement of his position. I told him that receiving an envelope full of scraps of paper, of photocopies taken from this document or that document, hardly constitute a worthy theological presentation of a position. When I asked him to draw up a formal statement, like a theological thesis paper which we could study seriously and respond to seriously, he agreed on two separate occasions to do exactly that. This theological paper never appeared, and then suddenly there was a statement, the statement that I just read to you, accusing us of not responding to the photocopies that had been sent to us. I don't understand how this could happen when the priest had assured me that he would do a more formal write-up, but I gather that perhaps he was too busy and perhaps he forgot. Nonetheless, the fact remains, at least I, speaking for myself, did not respond because I was assured there would be a more formal presentation and I was awaiting that worthy theological effort. But secondly, I really believe that there was no need to produce information contrary to what this priest had provided. And I believe there was no need to provide information contrary to what he provided because the quote that he provides is not a quote at all and doesn't prove the point that he is trying to make. he alludes to a statement by Pope Benedict XIV, which alludes to a statement by an earlier Pope, Alexander VII. But neither statement by Benedict XIV or Alexander VII is ever quoted verbatim. It is simply interpreted, what they said. This is very shoddy scholarship. Not only that, but even the interpretation of what is said is taken out of context and used to prove a point which the statements do not prove in any way. The statement that is given is that I discovered that Pope Benedict XIV discussed the matter at length and said that the whole question was settled by Pope Alexander VII, who said that even if a bishop without a papal dispensation should without any assistant priest perform an Episcopal consecration, it is to be deemed valid. And then he goes further and says, I found nowhere any evidence requiring qualified witnesses, and then he's making a presumption. He said, because I failed to find any statements of popes or theologians or canonists that qualified witnesses are necessary, therefore I presume that none are required. But that is a presumption, and that is not a safe theological and a worthy theological position to take based upon a presumption simply because he did not find evidence. And then writing to our priest and saying, since you did not provide me with the evidence that I seek, and I could not find any, I presume there is no such evidence. This is not theology. Now I know that an ordinary layperson reading these statements might be won over by them, but the fact is, these statements do nothing to establish the position which this priest is taking. And the position he's taking is this, really, if you follow it logically to its ultimate conclusion, that the Church has decreed that she will automatically and in advance accept all Episcopal consecrations performed without any witnesses. Period. And he's arguing from that conclusion to say, therefore, the lack of qualified witnesses at the consecration of Gerard de Laurier is not an impediment to accepting it. Rather, we must accept it as being valid. That is not at all proven by the statements adduced by this priest critic. This is not Catholic theology. That is another reason why I did not respond, and saw no need to respond, because I thought the case was no case at all. The case does not, the quote does not prove what he pretends. In fact, it's not even a quote. Furthermore, the statements even misrepresent our position, the position of the priests of St. Pius V. Even that was not gotten correct. Our position is simply what the Church prescribes. Assistant priests are required by the Church for the legality of an Episcopal consecration where co-consecrators are not present. This is required. That requirement can be waived by a dispensation from the Holy See. But where that dispensation is not granted, they are required for legality. That is our position, but again, we are misrepresented because the priest who criticizes us says that the co-consecrators, that is the two bishops who join the main bishop, the principal bishop, are not there as witnesses. Therefore, the assistant priests, who can sometimes, by papal dispensation, replace those co-consecrators, are not there as witnesses either. And therefore, he extrapolates this to say that no qualified witnesses are ever required by the Church. This is manifestly ridiculous. I did not respond to this because I found the argument absurd. It is an absurdity of false reasoning to claim that the Church automatically in advance accepts and deems as valid all possible future secret consecrations, regardless of the circumstances. That is not Catholic tradition. That is a departure from Catholic precedent. Now, in the document to which this priest's remarks are a preface, there are a number of cases given of secret consecrations which the Church subsequently accepted as valid. But rather than prove the case that this priest is making, those examples rather prove the position of the priests of the Society of St. Pius V. Our position is precisely that where you have a secret consecration, there is one authority and one authority alone that can guarantee the validity of that consecration, and that is the authority of the Church. So when examples are given showing that there was a secret consecration in 1943 behind the Iron Curtain or wherever, that the Church later endorsed and accepted as being valid, that proves our case. The authority of the Church is needed to guarantee the validity of such consecrations. And where that authority is lacking, no individual priest or no group of priests can get together and substitute for it simply on the basis of their personal opinions. They do not have the authority to substitute for the magisterial authority of the Church. We can't forget that, but there are traditional Catholic priests who are forgetting that to their own peril, and they are misleading many good Catholic people. Now, let's go back and look at the question as it is posed by this priest. The question that he posed to our priests. Is there a document refuting the quote or the reference given as proof that witnesses are not needed in order to establish the validity of a secret consecration? This is a false question if it is brought forth to pertain to the Thuc consecration of Gérard de Laurier. Why is it a false question? It's a false question because that consecration is a special case. It is a case in which there was no official record made of the consecration. Nothing like that is stated in the cases referred to by Benedict XIV or Alexander VII. They do not mention cases in which there is absolutely no documentation whatsoever. But in the case of Gérard de Laurier, there was no official documentation, no official record of the consecration. The witnesses are called upon to testify in default of such an official record. That's the role of the witnesses. So the quotation is not, I keep calling it a quotation, but there is no quotation. That's the point. He just makes a reference to something that one pope said about what another pope said. This reference is not the point, in that it fails to deal with the facts of the particular matter in question, this alleged consecration of Father Gérard de Laurier by Archbishop Nodentuk. That failure, that discrepancy, is simply ignored by this priest researcher as though it were of no consequence. Yet, as we shall see, it is of major importance. It is a central question. How is the conferral of orders to be proven in default of official documentation required by the Church? And let me address in my introduction to giving the evidence that he has asked for. Let me just state this final reason why I did not respond to him. Knowing the intelligence of this priest and the amount of time and effort that he says he expended in his research, I assumed that the information he demanded would be very, very difficult to find. I was wrong. One of the standard reference works in moral theology, used routinely by seminarians and priests alike, is the work of a Jesuit priest, Father Felix Capello, past professor of moral theology at the Pontifical University, the Gregorianum in Rome. It was in this easily accessible standard reference work that I found an answer which appears to me to be a straightforward, direct settlement of the question raised by this priest, our critic. But first, in order to understand what Father Capello says, one must know what the Church ordinarily requires by way of evidence to prove that an ordination has in fact taken place. And for this, all we have to do is turn to a law of the Church, Canon 1010 of the Code of Canon Law. Canon 1010 explains what the Church demands by way of direct evidence that an ordination took place, that a consecration took place. It says, after an ordination has been held, the names of the individuals ordained, the name of the minister of ordination, and the place and date of the same shall be entered in a special book, which is to be carefully preserved in the curia of the place in which the ordination took place, together with all documents pertaining to the ordination. To each candidate ordained, an authentic testimonial of the order received shall be given. But the question here is, what happens when there are no documents? What happens when the official records documenting the ordination have been destroyed or lost, or, as in the case of Father Gérard de Laurier, never made? What proof does the Church then require? That's the point. The eminent moral and sacramental theologian, Father Capello, explains in his excellent work, De Ordinatione, on the sacraments of the Church, and in this volume, on the sacrament of orders, published in 1935, to prove a conferred ordination if the documents of the archive have been burned or lost. One witness is sufficient from analogy of the law above every exception, provided that he be with prejudice to no one. And then the examples that are given are the bishop himself, the pastor, the Episcopal chancellor, and others of the same kind. Now, I know that statement might seem confusing at first, but it's of the utmost importance because it is exactly what our priest critic claims he couldn't find. To prove a conferred ordination, if the documents of the archive have been burned or lost, one witness is sufficient from analogy of law, a witness who is above every exception, provided that he be with prejudice to no one, the bishop, the pastor, the Episcopal chancellor. Now, what does this statement mean? Well, first of all, it means that if there are no official documents attesting to a consecration, a witness is needed. A witness is needed, and we're going to find out what kind of witness from this, what he says here as an analogy of law. A witness who is unimpeachable, whose testimony is unchallengeable. Omni exceptione maior, above every exception. And who is not prejudiced or biased in any way, provided that he be with prejudice to no one. The examples of such qualified witnesses would be the bishop himself, the pastor of the place, the Episcopal chancellor. That's the kind of witness they're talking about as required here to guarantee a consecration or any conferral of orders for which there are no documents. But what does this mean, ex analogia legis, from analogy of the law? See, this is very important, because in the law itself, it does not go into great detail about what is required to prove a consecration. Father Capello says we learn that by applying the same rules to proving the sacrament of holy orders as we use for proving the sacrament of baptism. That's the analogy. The analogy between the sacrament of holy orders and the proof necessary to establish it, the sacrament of baptism and the proof necessary to establish it. And the Code of Law does go into detail about what is required to prove baptism, and there are extensive commentaries concerning this proof. The canon of law to which Father Capello refers in his note on this statement is Canon 779. He says we should refer to that canon to understand what he means by this, what kind of proof is necessary. This is what Canon 779 says. Unless the rights of a third party are prejudiced thereby, one witness who is absolutely trustworthy, or the oath of the baptized party himself, if he was baptized at an adult age, suffices for the proof of baptism. What does this mean in the practical order? Well, two renowned canonists, both Franciscan priests, Stanislaus Woywood and Callistus Smith, wrote an explanation of this canon in their practical commentary on the Code of Canon Law published in 1952. And this is how they explained that canon. If the baptismal record has been properly made, it is full legal proof of baptism according to Canon 1813. Very important statement, because it says exactly what we're saying about holy orders. If the documentation, the official record is made, that is full legal proof. If, however, for any reason no record can be had, baptism must be proved by witnesses. Precisely our point with regard to holy orders. The general principle is expressed in Canon 1791, that the deposition, that is, taking testimony under oath, the deposition of one witness does not constitute full proof, unless he is a qualified witness who gives testimony concerning acts done in his official capacity. But when there is question merely of getting the testimony of baptism as it is required before confirmation, First Holy Communion, ordination, marriage, where the rights of third parties are not concerned, where it's just the individual himself, the testimony of one absolutely reliable witness who testifies out of his own personal knowledge is sufficient. So you see, even where the rights of a third party are not involved, there is still required the testimony of an absolutely reliable witness who testifies from his own personal knowledge. But in matters of ordination here, whether an ordination was conferred validly, you have the rights of hundreds, perhaps thousands of other people who are going to be going to this man to receive the sacraments. They are at stake here. And this commentary by these canonists says the deposition of one witness does not constitute full proof. He must be a qualified witness who gives testimony concerning acts done in his official capacity. In his official capacity. In all other cases where the rights of third parties are affected by the proof of baptism, for instance, in a marriage case in which the validity of the marriage is attacked on account of the baptism, one witness does not fully prove baptism or non-baptism. Now he says that when there is a question as to whether baptism should be conferred again, the Holy Office declared that the testimony of one trustworthy witness suffices to establish the fact of baptism, and the sacrament may not be repeated conditionally. But remember, he says, where one such witness testifies that the baptism has been properly conferred. So this tells us not only the kind of witness we need. Well, I should start with this. It not only tells us that we need witness, at least one witness in a case where the rights of no third party are involved, but we need more than that where the rights of third parties are involved. It tells us that we need witnesses. It tells us what kind of witnesses we need, absolutely unimpeachable, who can testify from personal knowledge of matters of which they know, and the kind of testimony they must give, that the sacrament was properly conferred. All of that is contained in these statements by these two very well-known canonists. This is a direct answer to what this priest says he has been looking high and low for and has been unable to find, and they are in standard reference works that would be on the shelf of any second-year seminarian. Now note this. Canon 1791 says this, because these commentators refer to that canon, and I think you should know what it says. The deposition of one witness does not constitute full proof, unless he is a so-called qualified witness, who testifies as to things done in his official capacity. For example, a pastor in reference to his pastoral duties or functions. If 2 or 3 absolutely trustworthy witnesses testify in court under oath as to some affair or fact, and do so of their own personal knowledge, and their testimony is strictly concordant, it is considered sufficient proof. If, however, in view of the very serious nature of an affair, or because of indications which create doubt as to the truth of things asserted, the judge believes it is necessary, he may demand more complete proofs. Now, that's a lot of words, but let's go through it again carefully, because a lot depends upon this, perhaps the validity of consecrations at holy masses that you yourselves might even be attending someday. The validity of holy orders that your sons might even receive someday from the descendants of the Thuc bishops. Look what this says here. Canon 1791. The sworn testimony of one witness does not constitute full proof, unless he is a so-called qualified witness. He must testify regarding things done in his official capacity. That is, would be the requirement, say, of a bishop who did the consecration, a pastor who does the baptism, and so on. If 2 or 3 absolutely trustworthy witnesses, other than this so-called qualified witness, if 2 or 3 absolutely trustworthy witnesses testify in court under oath, that's important, in court, as to some affair or fact, do so of their own personal knowledge. For example, that the matter and form of a sacrament were in fact conferred because they know what the matter and form of the sacrament are. And their testimony is strictly concordant. That means no contradictions, either among themselves or within the testimony of a single individual. Strictly concordant testimony. That is considered sufficient proof. This was not what our priest received from the professors who were the only observers of the consecration of Garde-Laurier. Their testimony was not strictly concordant, and they could not testify with regard to their own personal knowledge that the sacrament was properly conferred. But even beyond this, because of the very serious nature of this affair, or because of indications which create doubt as to the truth of the things asserted, the judge believes it's necessary, he may demand more complete proofs. And you see, that statement really answers a lot of the question here. We're talking about a court of law. We're talking about an ecclesiastical court with an ecclesiastical judge who is empowered by the church to make a decision with authority. None of us has that authority. None of us is that ecclesiastical judge or has the magisterial authority necessary. With regard to the whole point, though, getting back to the reference of our priest friend, are witnesses required? Is there any source that says witnesses are required? He looked high and low and couldn't find any. The Catholic Encyclopedia of 1907, the Catholic Encyclopedia of 1913, under the title Co-Consecrators, make it clear that the co-consecrators are there at least in the capacity of witnesses. This is what that article says. It is written by a Jesuit, Father Sidney Smith. Co-consecrators are the bishops who assist in the presiding bishop in the act of consecrating a new bishop. It is a very strict rule of the Church that there should be 2 such assistant bishops, or 3 bishops in all. Though an exception is made for missionary countries where it is practically impossible to bring so many bishops together. The Holy See there allowing 2 priests to act as assistants to the consecrator. But the question was proposed in this article as to whether or not the co-consecrating bishops equally with the consecrator impart the sacramental gift to the candidate. And Father Smith responds that he does not think so. Now remember, this was before the decree of November 30th, 1944 by Pope Pius XII, saying, establishing co-consecrators as fellow consecrators with the principal bishop consecrator. But Father Smith does acknowledge in this article that those co-consecrators are there in the capacity of witnesses. The question is not whether they're in the capacity of witnesses, but whether they're there in the capacity merely as witnesses, or also that they assist in conferring the sacrament. Father Smith actually quotes theologians to the effect that the co-consecrating bishops are there certainly as witnesses of the sacrament conferred. I am not going to read the entire entry because many of you will have this Catholic Encyclopedia and can verify it for yourself. Therefore, in default of the official documentation normally given with the conferral of holy orders, the Church demands unimpeachable witnesses that the sacrament was properly conferred. But it is not up to just anyone, a layman or a priest, to judge. Judgment is reserved to an ecclesiastical court, with a judge enjoying the authority of the Church. There is no substitute for this authority, nor is there any precedent in Catholic tradition for an ordinary priest presuming to assume this authority unto himself. And my response, therefore, to this priest would be, in the face of this, I do not understand how an ordinary priest can presume to sit in judgment, to guarantee the validity of the Thuc consecration of Gérard de Laurier when the Church requires, in default of any official documentary record of the consecration, unimpeachable witnesses, omni exceptione maiores, sufficiently qualified to testify under oath and before an ecclesiastical court that the consecration was properly conferred. But then this is precisely my point. And herein lies the root of the danger and the problem facing Catholics who are set on keeping the true faith. They must resist the temptation to overreach their competency. They must remain within the limits set for them by the Church's tradition. I know the sense of urgency that is felt there by some of the priests to find a solution to this very difficult problem of episcopal orders and episcopal powers. But we cannot jettison Catholic tradition in order to find a solution. That would be looking for the devil's solution to the problem that the devil has caused in the Church. Another case, and this is my final case, of priests falling into this trap of exceeding their competency involves that of Mount St. Michael. And it involves the whole question of whether Mount St. Michael is a schismatic institution. And Mount St. Michael, as many of you know, was an institution established by Francis Schuckardt. Francis Schuckardt, a member of the Blue Army back in the 1970s, who traveled the country giving talks about the Blessed Virgin Mary and the need to pray the Rosary. Francis Schuckardt went to a man named Daniel Q. Brown to be ordained a priest and consecrated a bishop. This was in the beginning of the 1970s, sorry. This was actually at the very outset of the 1970s that this took place. And Daniel Q. Brown had received his orders outside the Catholic Church. Brown had been a Catholic who left the Catholic Church, formally joining an old Catholic schismatic sect to be ordained a priest and consecrated a bishop. And sometime afterwards, Brown made an abjuration of heresy before 40 lay people in a hotel room in Chicago, Illinois, and then claimed he was reconciled to the Catholic Church and he was entitled to function as a priest and a bishop in the Catholic Church. Part of that functioning, as it turned out, consisted of ordaining and consecrating Francis Schuckardt a bishop. Schuckardt then joined forces with Brown to establish the Tridentine Latin Rite Church, and part of that church came to be known as Mount St. Michael, established in the vicinity of Spokane, Washington. Now in 1984, Schuckardt's followers, the clergy whom he had presumed to ordain, actually drove him out. And they drove him out because scandals associated with him became common in the press. Documentaries were being published and aired in the newspapers and over local television. And so Schuckardt's right-hand man for 9 years, the previous 9 years, oversaw the expulsion of Schuckardt, and then that Vicar General, Schuckardt's assistant, Dennis Chicoine, wrote a public letter dated June 21st, 1984. And in that letter, Dennis Chicoine explained why it was necessary and morally correct to expel Schuckardt from the organization. Dennis Chicoine explains in a clear and forthright manner, he says, why Schuckardt was finally ousted. Amongst the charges of incompetency and immorality is Francis Schuckardt's pretension to be the Pope. That is, Francis Schuckardt considered himself to be the Pope and wanted others to acknowledge him to be the Pope. This is the evidence quoted from Dennis Chicoine's open letter, and I quote Chicoine's words. I have in my possession a booklet written by a member of the community which bears the nihil obstat of Bishop Schuckardt. This booklet contains an erroneous history of Bishop Schuckardt's life, of his episcopal consecration, and makes reference to Bishop Schuckardt as Pope Adrian VII, and has a chart showing Our Lady of Guadalupe presenting the papal tiara to Bishop Schuckardt. I have in my possession sworn statements by several persons whom Bishop Schickhardt told personally that he was the Pope. These same persons were instructed not to tell myself and other priests and clerics, since we did not have the grace to accept it. Bishop Schickhardt has worn and wears a white cassock in the manner of a pope, not an Episcopal cassock. Bishop Schickhardt has allowed pictures of himself in a papal cassock to be made and disseminated among the religious and laity. Bishop Schickhardt, as so he styled himself, claimed to be the Pope. This is the very textbook definition of a schismatic sect. We are being asked to accept this institution as a Catholic institution. It's not the same as accepting an individual back into the church. It's being asked to accept an entire institution schismatically created as a Catholic institution. This only the supreme magisterial authority of the church can do. No priest, no group of priests has the authority to do so. This is another prime example of individual priests exceeding their competency. My dear fellow Catholics, we must stand firm and restrain ourselves within the binds and confines of Catholic tradition if we want to be Roman Catholics. God bless you.